Liz Murphy here to talk to you about the Care Talk tips for this month. I want to mention 3 topics, all of which are really important going into 2020 and all of which I'm sure you've heard about in the news. So number 1 is AB 5, independent contractors. California legislature has made it much more difficult for a person to be properly classified as an independent contractor. And there is a business-to-business exception, but all that means is if you qualify, the old test applies to determine whether a person is an independent contractor. So, the advice that I am giving is if you have any independent contractors that you're working with, either directly or indirectly, or if you contract with a company that itself employs independent contractors or engages, the recommendation is that you revisit those relationships carefully, because misclassification is very serious and we want you to avoid that. So the second thing I want to talk to you about is arbitration. I know you've all heard about AB 51. I got a lot of terrified calls from people saying, oh no, my arbitration agreement's not enforceable. And yes, the law does ban mandatory employment arbitration, but there is a carve-out for arbitration agreements that are governed by the Federal Arbitration Act. So you shouldn't just throw away your arbitration agreements. They're still good, but the advice is you should make sure you have a provision in your agreement that says it is governed by the FAA. And the other thing that you should really try to do is make sure that your agreement is no longer mandatory. It cannot be a condition of employment. So you may need to revise your offer letter, you may need to revise your arbitration agreement. The third thing I want to mention for today is that I know most of you, or hopefully all of you, have heard that employers with 5 or more employees are now required to conduct sexual harassment training. Well, in SB 778, they gave us an extension on that, so we didn't have to meet that requirement until the end of 2020. But unfortunately, if you are what's considered a temporary services employer, which home care companies may be, then that 1-year extension doesn't apply, and your employees must be trained within 30 calendar days of beginning employment or within 100 hours worked, whichever happens first. So the advice there is to be safe and just go ahead and get everybody trained. It's only 1 hour for your employees for 5 or more employees. So I want to say happy Thanksgiving, happy holidays. Thank you for listening. If you have any questions, please reach out. I'd be happy to help. Thank you so much.